what I'm saying.
Yeah.
1, 2, 3. It's moving.
All right. The only computer that is
So this is Recording in progress. Recording stopped.
Morning, members. Can you hear me?
Yes, Chairperson, you're audible.
Good morning, Chair. Who can hear you?
Thank you. Good morning, members. Good morning to you all. I see that some members are still connecting. Time now is 9:30. Let's resume with our meeting.
Recording in progress.
Please allow me to have my video off for better coverage so that you can hear me clearly. Members, today we are receiving a briefing by the Public Protector South Africa on report number 1 of 2024, systematic investigation into administrative deficiencies relating to gender-based violence within the South African justice system. So we'll receive that a presentation from the Public Protector, and then the committee will interact with it and try to flag some areas of oversight as well, going for oversight at the end of the year. So, Committee Secretary, do we have any apologies except the one of Honorable Swart of Wednesdays?
Chairperson, I think Mr. Swart is here, but besides that, I don't have any apology.
Thank you. He usually attends, then leave in the middle of the meeting. Good morning, PP and your team.
Good morning, Honorable Chair, and good morning to the honorable members.
Thank you. We'll give you just now. Let me first attend to Honorable Nomvalo. Honorable Nomvalo, your hand is up.
Yes, Chair, my hand is up. Good morning to you and to colleagues. No, Chair, I just wanted to forward an apology of Honorable Hlophe. And my apologies for tendering it in this manner. I should have submitted it to the Secretary, but I've realized that the meeting is now starting and the apology has not been submitted. So I want to to forward that apology, Chair. Thank you very much.
Thank you very much, Honorable Nomvalo. We note that apology of Honorable Hlophe. Public Protector, you will introduce the team you are with, then proceed with the report. Now the floor is yours.
Thank you, Honorable Chair, and good morning once more to yourself and to the honorable members.
Your voice, PP, sounds so low.
Chair, I think the Public Protector is muted.
Okay.
PP?
PP?
Utilizing a common speaker. Thank you. Is it audible now?
Yes, that's fine now. That's fine. You can proceed.
Thank you so much. Thank you. Good morning once more to yourself, Honorable Chair, and to the honorable members. I'll start introducing myself. I'm Kollega Galega, the Public Protector of the Republic of South Africa. With me, I have the team that is responsible for the production of this report. I have Advocate Nelisiwe Gabinde, our Chief Operations Officer. And I also have the Executive Manager Investigations, Ms. Bonateho Mohaladi, as well as Veronica Pillay, as well as Advocate Niels van der Merwe, who is the Head of Legal Services, as well as our spokesperson, Mr. Khulupasiwe, and the Chief of Staff, Mr. Gumbikelela. That is the Public Protector South Africa team. Chairperson, thank you.
Thank you, PP. You may proceed with the presentation.
Apologies, Chair, forgot to introduce the Chief Executive Officer who is with us as well. Ms. Apologies, CEO, Ms. Tanti Simanyoni, as well as our parliamentary liaison, Benita Young. Thank you.
Okay, proceed.
Thank you very much, Chairperson. I will then ask Ms. Mokhaladi, as the head investigator in this matter, to, with your permission, Chairperson, to please take the portfolio committee through this presentation. Just to give a brief background on our side, is that this was a twofold investigation, Chairperson, looking into the entire system, not just into gender-based violence, but also into the maintenance section of the Department of Justice and other departments which are interrelated into that. However, the investigation proved to be quite wide and vast, and we then separated the issues and then focused on GBV on its own, and the maintenance part of it is currently underway, and we are hoping that by the end of the third quarter, we will be able to finalize that particular investigation. So I'll then hand over to Ms. Mokhaladi. Over to you, Ms. Mokhaladi.
Thank you, Public Protector. Good morning, Chairperson and honorable members of the committee. The investigation focused on gender-based violence. Firstly, to start, the mandate of the Public Protector it's focused on Section 181 of the Constitution that establishes the Public Protector to strengthen constitutional democracy. The powers of the Public Protector are also regulated by national legislation in the form of the Public Protector Act. And it is to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice, to report on that conduct and to take appropriate remedial action. The Public Protector has additional powers and functions as prescribed by legislation in the form of the Public Protector Act, as well as the Executive Members Ethics Act. The Public Protector's principles and values are anchored on the Batupili principles, and we seek to uphold and promote the three key principles being accountability, integrity, and responsiveness. The jurisdiction areas of the Public Protector covers over 1,000 state organs, as well as other government agencies and all three branches of government, as well as other public institutions. There are about 47 national departments that are covered by the mandate of the Public Protector, as well as the provincial departments across the 9 provinces. Local government, we cover 8 metropolitan municipalities, 205 local municipalities, as well as the 44 district municipalities. Other organs of state, as well as the public bodies, includes universities, public entities, 9 institutions and commissions, as well as other statutory bodies and other institutions performing public functions. The
Chair, sorry to interrupt. I can't hear the presenter. Is it me or is there a problem with the audio from the presenter side?
I also can't hear, Chair.
No, it's not you, Honorable Mat. I think they got freezed and cut, so but the Committee Secretary is talking to them.
Thank you.
Oh, yeah, we can start. Okay. Apologies, Chairperson and honorable members. Can you hear us now?
Yes, we
Loud.
can.
Thank you.
Apologies, we were disconnected for a bit. Can you see the screen with the presentation?
Yeah, the screen it's a slide that investigation triggers.
Yes, yes. Thank you, Chairperson and honorable members. The investigation by the public protector can be triggered firstly by either a complaint being lodged by the victim directly with the public protector, or any person can lodge a complaint on behalf of any person with the public protector. Furthermore, members of the National Assembly, members of the provincial legislature can also lodge complaints with the public protector, as well as individuals, groups, organizations, or political parties and other civil society. The public protector can also investigate complaints on own initiative. These are mainly focused on systemic investigations or root cause investigations, or where we pick up trends from existing complaints. It can also be based on information that is in the public domain, such as the print media, social media, and other platforms, including public debates. Okay. Apologies, Chairperson. The slides are not moving. We are trying to sort it out from our side. Okay. The investigation process of the public protector follows 4 steps. The first being what happened. In the what happened, we establish the factual versions of the complainant as well as the organs of state. The proof is on a balance of probabilities. It is achieved through documentary as well as explanation requests, interviews, or hearings. What should have happened? We determine the legal and regulatory framework that governs the issue that is being investigated. Mainly, we will be looking at constitutional provisions as well as other legislative prescripts. The third step, we look at whether is there a discrepancy between the what happened and what should have happened. We conduct tests that transcends on lawfulness. Is there a gap between what happened and what should have happened? And we determine whether the complainant suffered any prejudice. Finally, we take what is termed the appropriate remedial action by the public protector. Simply, it says, in the event that we found that there is a service failure, what did it take to put the complainant in the position that he or she would have been? We try as much as possible to bring the victim of maladministration closer to the position that he or she would have been had the maladministration or the wrongful conduct not taken place. Now focusing on the systemic investigation. The systemic investigation focused on the 3 departments, firstly being the Department of Justice and Constitutional Development, South African Police Services, as well as the Department of Social Development. It was triggered by a complaint that was lodged with the public protector by the former Minister of Justice. He requested the public protector on the 18th of June in 2020 to look at the case that was reported in the media relating to the case of Ms. Korki. The factual background to the case of Ms. Korki was that she approached the Bellville Magistrate Court on the 8th of June to apply for a protection order. She was registered in the register that is used by the clerk of court. She was given a form that she was supposed to complete. However, after waiting for a while, she left. And she explained to the person that accompanied her that she did not expect that the process would take that long, or the form that had to be completed would be that long and it would be complicated. The public protector investigated that complaint. Our findings was that there was no wrong conduct on the part of the court officials. However, based on the challenges that were experienced by Ms. Gorky, the public protector decided to conduct a systemic investigation in consultation with the Department of Justice and Constitutional Development. What happened in the case of Ms. Gorky was that, unfortunately, 4 days after she had approached the Bellville Magistrate Court, she was murdered by the partner. So the background to the systemic investigation was based on the issues that arose and the circumstances that led to her being murdered by the partner, but not really focusing on the criminal aspect that was being investigated by the police. But we focused on the administrative side, being the 3 institutions that were investigated. The issues for investigation against the 3 institutions with regard to the Department of Justice, the issue for investigation was whether the Department of Justice did not put adequate measures in place to protect the victims of gender-based violence. And with regard to the South African Police Services, whether the South African Police Services did not put adequate measures in place to respond to incidents of gender-based violence. With regard to social development, the issue was whether the Department of Social Development did not put adequate measures in place to support the victims of GBV. The issues were identified mainly based on the mandate of each of the 3 institutions. The process that we followed as part of what happened. We conducted an inspection of the 38 courts that were identified across all the 9 provinces. As part of the investigation, we visited those courts and we conducted an inspection in loco. We interviewed the court users as well as the staff at the various magistrate courts that we visited. We also had an engagement with the NGOs. We identified 3 key NGOs that operate in the GBV space, being Mosaic, People Opposed to Women Abuse, as well as Wise for Africa. We also conducted an inspection of the Gender-Based Command Center that operates under the Department of Social Development. We also inspected one of the GBV shelters that has been established by the department. It is the Mali Martin Mbulugen Center that is based in Bronkhorstspruit. We also received written submissions from the Department of Justice, SAPS, DSD, as well as NPA. With regard to what should have happened, we looked at the following key prescripts: the Constitution, the Domestic Violence Act and its regulations, as well as the Domestic Violence Amendment Act and its regulations. The Domestic Violence Amendment Act was promulgated in the middle of the investigation, so we considered it as well. We looked at the Magistrate Courts Act. We looked at the Government Immovable Assets Management Act, the National Archives and Record Services Act. We looked at the South African Police Service Act and the National Instructions of SAPS. We also looked at the National Prosecution Act, as well as the National Gender-Based Violence and Femicide Act that was promulgated towards the end of the investigation. With regard to the findings against the Department of Justice, the first finding, we looked at the infrastructure in the courts that we visited, and our finding was that out of the 38 courts that we visited, only the Point Branch Family Court in KwaZulu-Natal is the one that was kept in an operational manner that supports efficient service delivery as required in terms of the Government Immovable Asset Management Act. The finding was based on the following. Firstly, some of the courts that we visited are old, dilapidated. The picture there is a depiction of the Garangua Magistrate Court. What we picked up during the investigation was that the Department of Public Works should have renovated this court more than 10 years ago, but currently it is in the state that it is. So the picture reflects the room in one of the records room at the Ga-Rankuwa courts. Also, some of the recently renovated courts, such as the Palm Ridge, they have structural defects in the form of cracked walls and roof leaks. Furthermore, there are inadequate office equipment. In some of the courts that we visited, the telephones, the photocopiers, and the computers were not working at the time. The electronic case management system was not working at most of the courts that we visited, resulting in the manual capturing of cases. There were also incomplete building projects in some of the courts. For instance, the Mamelodi court, that project has been standing incomplete for the past 10 years. Also, some of the courts, such as Mamelodi, Ga-Rankuwa, do not have proper waiting areas. The picture on the right depicts members of the public waiting in it's a parking area that is converted into a waiting area for the court users. Furthermore, the courts do not have sufficient private consultation room. In some of the courts that we visited, such as the Ottosdal Magistrate Court, the clerk of courts are sharing offices. In some of the courts, when we inspected, we found that they would be consulting with 2 court users at the same time. There was no privacy with regard to the issues that are being reported by the court users. Furthermore, in most of the courts, they are inadequate. There are challenges related to human resource capacity constraints. In some courts, they would have only 1 magistrate, and also the clerk of court, there was insufficient capacity. It led to long delays as well as the queues by the court users. Furthermore, the majority of the courts do not have proper filing system and spaces. Most of the courts that we visited, except for the Point Family Court, the files were either scattered on the floor. In the picture there, it is the picture taken from Ga-Rankuwa Magistrate Court. The police cell is used as a filing space, but even the files there, they are not properly filed. They're just laying there on the floor. We also picked up that there is no separation between the maintenance as well as domestic violence and harassment files. The effect of this is that it takes long to try and retrieve the information. There was also a lack of assistance being provided to applicants to complete the application forms. There were long waiting times and inconsistencies in the timeframes according to which the protection orders are dealt with across the various courts, which are linked to insufficient capacity. Linked to this was that in some courts, they would set aside only 1 day for dealing with cases of GBV and domestic violence. There is also lack of communication with applicants or the court users in the language of their choice. The Domestic Violence Act and the amendment requires the victims to be communicated with in their language of choice. But however, due to capacity constraints, we picked up that in most of the courts, the language that would be dominantly used would either be English or Afrikaans. Following that, the remedial action that we took against the Department of Justice, when we issued the notice, the Section 7 notice, they agreed to the findings that were made. They also provided us with an action plan highlighting where they are in terms of some of the findings, but they fully agreed with the public protector and also with the remedial action plan. The remedial action that was taken, they made inputs. It was agreed to between the public protector and the department. The first one is that within 210 days, the department must develop the standard for a model court that will include all infrastructure such as buildings, human resource capacity, ICT, furniture, and office equipment that will be adequate for the various levels of the courts to ensure optimal service delivery. We said, because there are various courts that has been established, the standards should be based on the needs of all the courts. It shouldn't be a one-size-fit-all, but they should take into consideration the needs of the various courts. Furthermore, within 180 days, they must conduct an audit of all the courts to establish the needs in terms of infrastructure, what upgrades are required, as well as the renovations that needs to be completed in the various magistrate courts. Furthermore, within 180 days, they must submit to the public protector a detailed project plan for the construction, renovation, or procurement of all courts identified in the audit, with clear dates, turnaround times, targets, and deliverables indicating how buildings and ICT will be upgraded, and a procurement plan for the furniture and office equipment. Also, within 180 days, to determine the human resource needs of the various court and develop a plan with clear targets and deliverables, timelines, dates indicating how the capacity constraints in the court will be addressed. During our discussion, the Department of Justice raised challenges regarding the constraints with regard to the filling of posts, but they have indicated, I will come to that slide that indicates how they will overcome those challenges. Furthermore, within 210 days to conduct an audit of the current filing systems in place at the various magistrate courts and develop and upgrade their filing system in line with the National Archives and Record Services regulations. Within 180 days, implement wider language options for print, oral communication based on the needs of each court, and simplify court application forms. Also, within 180 days, to ensure that the online portal for application of protection orders is functional and available in all courts to assist the complainants or applicants when applying for protection orders. What we picked up is that although the Department of Justice had rolled out the online portal, at the time that we concluded the investigation, we tested it prior to issuing the notice and after, before we issued the report. It was not fully functional, hence the remedial action is based on that. With regard to the South African Police Services, our findings with regard to the South African Police Services was that some police stations do not have a victim-friendly rooms as required in the national instructions of the South African Police Services. The SAPS national instructions require that all police stations should have victim-friendly rooms that should be used for consultation with the victims of GBV. As a result of the lack of victim-friendly rooms, the victims are forced to relay their stories of abuse in crowded police stations. What some police stations have done is that they have demarcated what they call the charge office, which is the front area of the police stations. It is just a little cubicle that is created to consult with the members of the public. In responding to the notice, SAPS considered that there are 141 police stations that do not have victim-friendly rooms. An analysis of the list that was provided by South African police indicates that those are mainly police stations that are in the rural areas. Furthermore, the Domestic Violence Act requires SAPS to make sure that if they are attending to cases of GBV, they must make sure that the victims are provided with medical attention or they are sent for medical attention. However, our findings based on the information that we received from the NGOs was that the victims are sent to courts without receiving medical attention or without being referred for medical attention. And the clerks of court are forced to arrange for such services. This is contrary to Section 2A of the Domestic Violence Act, read with paragraph 6 of the South African Police National Instruction 7 of 1999. Furthermore, some police members, even though they are aware that a criminal offense has occurred, they are reluctant to register cases of the criminal cases and do not inform the victims of their rights to institute criminal action against the perpetrators, but they rather refer the victims to court to apply for a protection order. This is contrary to the provisions of the legislation, which requires SAPS under such circumstances to assist the victims to register a criminal case or to inform them of their rights at the scene of the incident of OGBV or soon thereafter. The other finding was that some police officials do not address the perpetrators without a warrant when there is evidence of violence. This is contrary to the provisions of the Domestic Violence Amendment Act, read with paragraph 14 of the National Instructions, which states that as soon as there is evidence that there is violence that has been against the victim, the SAPS has the right to arrest the perpetrator without a warrant of arrest. Furthermore, I have covered the VVFR. Some of the victims are sent to courts. Apologies, Chairperson, some of the slides is duplicated. You can go to. Okay. Okay. What we have also found is that some applicants are often left on their own to serve the respondents, thereby making them vulnerable. In terms of the requirements of the Domestic Violence Amendment Act, SAPS must accompany the victims of GBV when they require service of the protection orders. So our finding was that the applicants are often left on their own to serve the protection orders, thereby exposing them to further attack. And furthermore, in terms of Section 13(1), the Act provides that the service of protection orders can either be effected by the clerk of court, the sheriff, and a peace officer, but in some instances, there was non-compliance by members of SAPS. We have engaged with SAPS around the interpretation. However, in terms of the mitigating factors, the service now in terms of the amendment can be effected either by electronic mail, being the email. So it will overcome some of the challenges that are being experienced by the victims. But our investigation was conducted prior to the amendments of the Domestic Violence Act. Furthermore, in some instances, there are delays by South African police services to respond to scenes of domestic violence or to provide assistance to victims. With the SAPS, in responding, they cited that they do not have sufficient vehicles to deal with the cases. Our finding was that this is contrary to the provisions of the National Instructions of SAPS, which states that as soon as a case of GBV is reported, SAPS must, without any reasonable delay, ensure that a police vehicle is dispatched to attend to the matter. Furthermore, our finding was that there is inadequate training for members of SAPS. Yes, we have found evidence that SAPS is conducting training on GBV. But however, our view was that due to the challenges that are being experienced, it is not really focused on the impact of GBV on the victims as well as on their families. And furthermore, we picked up there is no effective collaboration between South African Police Services and the Department of Social Development. In terms of the Domestic Violence Act, as soon as a case is reported to SAPS and they are aware that firstly, the victim require medical attention or needs protection in the form of being moved away from their home, they are supposed to collaborate and engage with the Department of Social Development and provide services such as trauma counseling, referral to the shelters and health services. But our finding was that this is not happening. There isn't sufficient collaboration between the two institutions. The remedial action against SAPS is that within 180 days, SAPS needs to conduct a needs analysis for all police stations that do not have the victim-friendly rooms and submit an implementation plan for the efficient response to GBV cases. The plan should include short, medium, and long-term interventions that are going to be put in place. Furthermore, within 180 days, SAPS must conduct regular training, focusing on gender sensitivity, the seriousness of GBV, and its impact on victims and the society at large, and the practical application of the Domestic Violence Act regulations, and as well as the South African national instructions. We noted, they provided us a list of the training, but however, our view was that it needs to be made more practical to make sure that members of SAPS are able to respond adequately to cases of GBV. And within 180 days, to make sure that there is that collaboration between SAPS and the DSD, the remedial action is that they must develop and submit to the public protector a collaboration plan between SAPS and the DSD relating to the provision of support services to the victims of GBV, such as trauma counseling, referral to shelters, and any other effort within this ambit. The findings against the Department of Social Development was that the evidence indicates that there are insufficient shelters to cater for the victims of GBV, which is contrary to Section 27(1) of the Constitution, which provides for everyone's right to have access to social security, including if they are unable to support themselves and their dependents appropriate social assistance. The key prevention and support programs that are being implemented by the DSD do not have sufficient human resource capacity to support the efficient service delivery. Furthermore, our finding was that the Gender-Based Violence Command Center, which has been established mainly to respond to cases, it is an online system where the victims can call or SAPS can connect them to the GBV, to the command center to seek help. We found that it was not adequately resourced. And initially it started with a staff complement of about 65 social workers. At the time that we concluded the investigation, there were only 38 field posts of social workers, and there were also only 6 officials that were providing technical support. And the GBVCC, which is based in Pretoria, is supposed to provide services to the entire population of South Africa. So with only those 38 and the 6 officials who are the support staff. Furthermore, the DSD has put other programs that are aimed at educating members of the public about GBV. Our finding was that one of those programs is called the Everyday Heroes Program. It is not adequately resourced and has approximately 370 trained ambassadors who market and promote the empowerment of victims and crime-related services. The 370 ambassadors provide services to the entire population of South Africa. Furthermore, there is a lack of multi-sectoral approach where all relevant departments can work together and have an integrated and an electronic data management system in relation to cases of GBV. The remedial action against the Department of Social Development. Firstly, we said within 180 days, the Department of Social Development must submit to the Public Protector a detailed project plan to determine the human resource needs of the Gender-Based Violence Command Center and to develop a plan with clear timelines, dates indicating how the capacity constraints in the GBVCC will be addressed. And also within 180 days, the DSD must submit to the Public Protector a detailed project plan to determine the needs for additional shelters for victims of GBV and develop a plan with clear timelines and dates indicating how the needs for additional shelters will be addressed. Further, as the same remedial action cuts across both the DSD and SAPS, that they should develop a collaboration plan that must be submitted to the Public Protector within 180 days. As I have stated, both 3 departments, they agreed to the remedial action as proposed by the Public Protector. They agreed to the findings and the remedial action. They also provided us with updates on how far they are in implementing the remedial action. Firstly, with regard to the remedial action against the Department of Justice, they indicated that the model code blueprint is in the process of being finalized, and they will be finalizing it in consultation with the Department of Public Works, as well as the judiciary. Furthermore, they indicated that more dedicated sexual offences courts are in the process of being designated by the Minister of Justice and Correctional Services. They acknowledge that more needs to be done to develop the court's infrastructure to be victim-friendly, especially in GBV and sexual offences and domestic violence cases, and has undertaken to coordinate with the DPWI in upgrading all the courts. And they also indicated that they have started the process of auditing all the courts' infrastructure to determine the needs of the various courts. They will prioritize this. However, due to the financial constraints, the department has indicated that they are dependent on National Treasury providing funding. However, they have undertaken within the available resources to prioritize, especially the courts that were identified in the report, to make sure that there is sufficient resources. And also they have started the process. The DG indicated that he has started the process of consultation with the DG of Public Works to make sure that all the projects that are identified for renovations, there is that ongoing engagement and reporting back between the two DGs. Furthermore, the department indicated that there is a detailed project plan for the construction, renovation, and procurement of all courts identified in the audit. That is the 37 courts that we have identified in the investigation. They indicated that there is a detailed project plan. And with regard to addressing the ICT challenges, the department indicated that they have appointed a chief information officer at the level of DDG, and with a view to prioritizing the ICT modernization and upgrading. And also additionally, at the time, just after we finalized the report, the department indicated that they have procured 600 personal computers and laptops that would be distributed to the various courts. And they have also procured about 600 scanners that will be distributed to the lower courts to facilitate the uploading and scanning of documents into the integrated electronic repository. They have also procured a telephone system that will address the challenges of the intermittent malfunctioning of the telephones. The scope of the procurement is inclusive of maintenance and support. They have also commenced on upgrading the local area network as the wide area networks at the 361 court sites. With regard to the addressing the human resource challenges, the department indicated that they are in the process of putting together a list of all the critical posts that require to be filled, and they will embark on the process of consulting with the Minister of Public Service and Administration, as well as the National Treasury, with an urgent business case for the purpose of allocation of additional resources to ensure that those posts are being filled. Furthermore, the department has also provided us with a schedule of training that would be conducted by the Justice College. The date started in June up to the end of the financial year in March 2025. They have also included the need for purpose-built record rooms in the specifications for all courts that needs to be upgraded. And they have also started an initiative to digitize and store existing court records electronically in the various courts. And they were also piloting the the IER, where files of domestic violence were opened with effect from the 16th of December, 1999. They started the process of piloting this and making sure that all the records are uploaded on the system. And the department has also appointed 9 provincial language managers. And their key duty is to ensure that language spoken in each province are readily available in terms of interpretation and other language services. Regarding the accessibility of courts after hours, the department indicated that all district courts, as well as the magistrate court, including the rural-based one, are required to keep a daily after-hours roster of court clerks as well as magistrate who are on standby so as to make services of the application of protection orders available on available throughout the 24 hours. Furthermore, there is an online solution for application for domestic violence protection orders. It is available, it's a web-based application that is available. The issue that we had with the department at the time was that, what about the people who are in the rural areas who might not have access to smartphones? But the department has given us the assurance that it is available on a normal cell phone. You don't need to have a smartphone to be able to access the online portal. Furthermore, in addition, the department has gone a level further to provide us with copies of detailed plans that came from the 9 provincial heads of the Department of Justice regarding to all the details finding on that we made at the various courts. They provided us with the detailed plans from the court managers. With regards to SAPS, the update that they has provided us is that they have amended their directives, including the national instructions, on various aspects in line with the amendments to the Domestic Violence Act. This inter alia, including instructions on sexual offenses, as well as the national instruction on domestic violence. SAPS has also indicated that the training material and training interventions have been initiated in compliance with the recent amendments to the Domestic Violence Act. With regard to the provision of victim-friendly rooms, SAPS has indicated that the Division Supply Chain Management Act has completed a contract to provide victim-friendly rooms over the next 5 years. In terms of the plan, SAPS will provide an average of 20 VFRs in the form that would be in the form of park homes. They will be using the park homes. So if we looked at that 20 and taking into consideration that they have a shortage of about 141, that plan is aimed at addressing that shortage of 141 VFRs in the various police stations. And they also indicated that GBV desks have been established and are functional at all police stations within the provinces. And in terms of the list that has been provided to us, it stood at 1,159 police stations. With regard to DSD has indicated that the HR unit has been tasked with developing a plan that focuses on the assessment of the overall department's capacity and workforce, aimed at addressing the workforce challenges. The process includes prioritizing the GBVCC that has been identified in the report. Regarding the GBV shelters, there are currently 47 districts with established shelters which are fully operational. But however, in the current financial year, additional shelters have been provided in the three provinces, one in the Northern Cape, one in the Northwest, as well as 3 in Limpopo. At the time that we conducted the investigation, Limpopo did not have any shelter that was run and managed by the department. They collaborated with the NGOs, but they have provided us with evidence that 3 shelters have been established in Limpopo. The DSD has managed to secure funding from the partners such as the EU, as well as CARA funding to support this initiative of providing the initial shelters. Thank you, Chairperson, and I will hand over back to the Public Protector.
Thank you very much, Ms. Mohaladi, and thank you, Chairperson. I just want to make the following highlights. So that, mostly affected areas is the rural areas in respect of this, as much as the semi-urban and urban areas are bad, but the rural areas are mostly neglected throughout these departments. So as you've noted, we've made a reference to the Department of Public Works and Infrastructure as well as to Treasury, even though these investigations were not focused on these two departments. We did interact with these departments. A copy of the report was sent to Treasury. A meeting was held with DPW, and they also had plans in respect of the refurbishment and further infrastructure development in respect of these courts, because some of them, as we have noted in the report, the critical issue is really the issue of space and infrastructure in order to be able to be a conducive environment for gender-based violence, victims. We also interviewed the National Prosecuting Authority as well as the judiciary to get their views in respect of the systemic issues really affecting the portfolio. And some of the matters that we had come across, the Department of Justice had started working on them even before our report was actually finalized. But what I would also humbly request, Chairperson, for the Portfolio Committee to assist us in is also interactions with the Portfolio Committee for the police as well as for social development. Collaboration and interdependence in line with Section 41, subsection 1 of the Constitution, we've actually found to be lacking, which was communicated to the departments, except for the areas where the integration was customized, for instance, like the Tutuzela care centers. So most of the areas do not have the Tutuzela care centers, and that is where we found most of the neglect to be at. So with that said, Chairperson, I'd like to hand over to you. Thank you very much, and thank you so much to the committee for really providing us with this opportunity to clarify our report, to enable the committee to perform oversight with the information that we have provided. We are available for questions that members have. Thank you.
Thank you very much, PP and your team. Members, that is long and short of the presentation. Now we're going to take members. So it's going to be Honorable Swart, Honorable Breitenberg, Honorable Dan, Honorable Glover, Honorable Zotetsi, Honorable Matafa, Honorable Nomvalo, Honorable Motawu. Members in that order, Honorable Swart.
Thank you, Chair. With your permission, I'll turn off the camera. Chair, I really appreciate this opportunity. I think this matter is far more important than any other meeting I might have. But I do want to commend the Public Protector on this very detailed report. I think it is excellent. And what makes it more astonishing is the fact of what she has uncovered in the various sectors and her staff. Chair, we passed a number of amendments to deal with gender-based violence, such as the Domestic Violence Act, and to now hear the lack or the blatant disregard of the instructions and the provisions of the Act by the police, for example. The national instructions is absolutely disgraceful. And we really welcome the fact of this deep dive into these issues. Chairperson, it's not good enough to say that there aren't enough resources for the police and insufficient training. I'm absolutely shocked that there would be victims of gender-based violence that have to go to court that do not receive medical treatment. And we need to express our views on this in a very strong way and to be grateful to the Public Protector for this investigation and for the remedial action that has been passed. Chairperson, we know there are financial constraints, but that does not give any excuse for the state of courts. We did our investigations in the last, our oversight visits in the previous parliament, but to see the state of the courts, and now suddenly there's a whole lot of remedial action and plans that are coming in by December. It's almost an indictment on previous parliaments and our oversight capacity, but we welcome the fact that there seems to be steps in the right direction. A specific question to the public protector, she made a mention right at the end, the care centers. Now, these are, obviously, there are not enough Thuthuzela care centers, but in the engagement with the department, and this is something we with the department as well, the further rollout of more Thuthuzela care centers, particularly in the rural areas, is obviously paramount and was this part of the discussions. Chairperson, I fully support the recommendation that we, as a portfolio committee, should meet with the portfolio committees of social development, of SAPS, of public works, to look into these matters. We will be embarking on the budget review and recommendation process. And this report will really be helpful to us to do deep dives into the Department of Justice. But we would definitely need to consider having a meeting, and the 180-day turnaround time for the public protector would be in December. So I would suggest next year that we have that joint meeting where we can get feedback from the public protector as to which remedial actions, which we know are binding, have not been complied with, and where we can exercise further oversight. Chairperson, I'm pleased that the public protector also referred to National Treasury, because obviously that is what, and that is unacceptable, but we do understand it to a certain degree, and these issues must be addressed either within the existing budget or, again, Chairperson, I've focused and I've emphasized this for many years. We as a portfolio committee, following our budget review process, can make suggestions to the appropriations committee for an increase in the departmental budget within the fiscal framework. Chairperson, for the time being, that will be my questions. I just wanted to again commend the public protector on this report. Thank you.
Thank you, Honorable Swart. Honorable Breitenbach.
Thanks, Chair. Good morning to everybody. Yes, Chair, I absolutely agree. What a really excellent report. Very detailed, covering a very wide span of issues. Needs to be commended, absolutely. An outstanding report. My concern is, Chair, that the turnaround times are not met. And I think we should, as a committee, request the public protector to occasionally update the committee. It doesn't have to be in person, just in writing, on how on what the progress is with regards to turnaround times, because I'm afraid that the 180 days might pass and plans are developed, and you can develop wonderful plans. It's the implementation that matters. And my fear is that the plans that are developed will not be implemented, and the excuse will be, as the Honourable Swart said, no money. So we need to find a way of dealing with that. And as a committee, we need to find a way of assisting the public protector to get these plans that are going to be drafted implemented. So if they would be so kind as to update us, that would be very helpful. Then, Chair, my further question is, on these visits where you looked at the facilities available, on my own experience of oversight over courts, wherever I go, is that they have these victim-friendly rooms, or they have these rooms that are meant for, particularly child witnesses, but they are dysfunctional. There's a brand new court in Plettenberg Bay, for instance, that has got a state-of-the-art room for child victims to testify from, and nothing works. The TV has been ripped out of the wall. The chairs are all broken. It's not a room that is functional at all. So they have the room. If you ask them, do you have a room? The answer is yes. If you go and have a look at the room, can you actually use it? Absolutely not. Did you look at that, and did you notice any issues with those rooms that they have? When they say they have them, do they actually function? Because my fear is that there are more courts like that where they don't function. Tutuzela centers are essentially a collaboration between the NPA and the Department of Social Development. So I think between them, we should help them compile a sufficient budget to in fact roll out more of those, although they are very expensive. I'm perfectly aware of that, but they do great work. So thank you, Chair. Those are my questions, and very well done on this report.
Thank you, Honorable Dana.
Thank you, Chair. Good morning to everyone. And let me join the colleagues in saying thank you for the very detailed, but I must say very upsetting report. We really do appreciate it. Chair, I just have a few questions. And you must excuse me if I repeat some of the questions that the colleagues have asked already, or if I touch on things that have been dealt with during the 6th administration. I would like to start with the courts and the court facilities and the court upgrades and the court buildings and court repair work. And Chair, I really want to make a suggestion. I know the complaint has been heard many times. I don't know if the suggestion has been made that we ask the Department of Public Works to appear before the committee so we can get a comprehensive plan of what they are doing with regards to court buildings and court facilities. I received a complaint during the week of the Potchefstroom Magistrates Court where the roof fell in, and I understand that the Portfolio Committee did an oversight visit to the Potch Magistrates Court during the previous administration. But that court is still dysfunctional. That court can still not be used. Some of the cases are being taken to the City Hall in Potchefstroom, and it especially affects the Children's Court and the Maintenance Court. So it all is intertwined with the problem of GBV. So we would have to, I really want to suggest that we get the Department of Public Works to come and account to what the plan is with regards to court buildings. Secondly, Chair, victim-friendly rooms, it has been mentioned, and I'd also like to ask with, I think we should get the department to come and account with regards to training for victim-friendly attitudes by court staff, and also I would like to agree with Honourable Swart that we also get the Department of Police to come and account to what is the situation with regards to training, sensitivity training, to training, with regards to excuse me, victim-friendly attitudes. And then it's absolutely shocking to hear of the lack of resources of the GBVCCs. There's only, I think, 38 social workers, while there are literally hundreds of social workers sitting at home unemployed. That really we have to get answers from the department with regards to that, Chair. I'd like to know exactly when the timelines given to the department started. And then I'd also like to request, I think one of the colleagues has mentioned it as well, that the Public Protector also come and report to us what has been done by the Justice Department. Have they kept to the timelines? Have they done what they were supposed to do, what the recommendations were? Then with regards to, it's for instance now, the CIO, the presenter indicated that the department confirmed that the CIO has been appointed to look at the ICT problems, but it's standard. Everyone has to have a CIO. So saying that the CIO has been appointed isn't really feedback. I think we should get detailed feedback on each and every recommendation by the time that the timelines have ended, so we can know what exactly has been done by the department, because it doesn't seem to me that that this absolute pandemic of GBV is being tackled with all the resources available and all the will and political will that it should be tackled with. Chair, then I'm almost finished. I'd just like to know what the address or the process is for accessing the online portal, especially if you don't have a smartphone. And I'd like to know if this is being advertised, is this common knowledge, and if not, how will it be advertised so people have access to it? And then also with regards to the Tutuzela care centers, the Justice Department, if I remember correctly, made budget available in its budget, even though the budget for GBV related matters has been cut. The Justice Department budget available for more Tutuzela care centers. And I think we should inquire from the department, what is the stance on that process? How far are they? Have more Tutuzela care centers yet? And we should get feedback on that. Thank you, Chair.
Thank you, Honorable Tsotetsi.
Thank you very much, Chair, and greetings to the public protector, members of the committee, and everyone that is in the platform. Chair, I think it is worth noting that the matter was taken. The matter which we're dealing with today was actually launched or taken up with the public protector or requested to be investigated by Judge John Jeffrey, who at the time was a deputy minister of the Department of Justice. I think that it's worth noting because for me it's a positive development or a consideration on the part of the deputy minister. Now, also worth noting, Chair, is the fact that on the remedial actions, this report places emphasis on what this committee would have dealt with and or would have made mention of on the meeting which this committee had on the 4th of September, wherein we would have said that we needed to develop a framework on what constitutes the adequate court for purposes of oversight. I think that such a framework must then also look at including issues that have been raised as part of giving support to the gender-based violence victims, so that we also live up to the expectations of this report. Now, Chair, it is also worth noting that the outcomes of this report comes after the President signed into law the Gender-Based Violence Act, which then captures additional expected procedures on handling of gender-based violence matters, and which also must be taken to consideration. Now, the finding speaks mainly of 3 departments which must interlink in order to process matters relating to gender-based violence cases. Now, it may therefore require that these portfolio committees, portfolio committees that are responsible for these departments must come together, Chairperson, and determine the modalities which they will use to jointly do oversight and ensure that the remedial actions as tabled by these reports are done with, and they are done within the time frame which is determined in this report by the public protector. So we must definitely come together and then say to one another, what do we then do with these things? How do we ensure that we play oversight on the departments to ensure that they are able to deliver on the expectations of the report from the public protector. Now, Chair, I would have also wished that we note and acknowledge that notwithstanding all the challenges that are and the deficiencies that are raised by this report, there is a significant progress that has been registered in the fight against gender-based violence and femicide. For instance, in terms of what is reported, out of 517 cases of femicide, the conviction rate is that 475 of them, the convictions around all these cases is 475. which then constitute 91.9% of the conviction rate. In terms of sexual offenses, out of 4,460 cases, rather out of 4,627 cases, you have a conviction rate of 74.8%, which is made up of 3,460 cases. In terms of intimate partner femicide, out of 386 reported cases, you have convictions of in over 356 cases, which then makes up the 92.2%. But however, Chair, the Commission on Gender Equality has identified the non-reporting and the withdrawal of these cases, of the gender-based violence cases, as one of the factors that are keeping gender-based violence alive. Now, in this regard, we may need social development or any relevant department to drive gender-based violence awareness campaigns and creatively develop other modalities of overcoming this problem, which arises as one of the drivers or one of the issues that are keeping gender-based violence alive. Now, we must, of course, thank the public protector for this sterling work that they've done. But also, Chair, hit the ground running in as far as ensuring that all these issues which he would have mentioned as the remedial actions are undertaken and they are addressed as a matter of agency. Of course, taking into cognizance the fact that gender-based violence is identified as the second pandemic which the country faces. Thank you very much, Chairperson.
Thank you very much, Honorable Klopper.
Thank you, Chairperson. Thank you to the Public Protector for the report. It shed light on many issues that the general public is facing. And it also highlighted the failures in the department. Some of these failures, I think, do not seem like they should actually be there in the first place. So they're almost obvious by nature. One of the things that I found is, how can the court only have 1 day set aside for protection orders, on some courts especially? What happened to the victims in the interim? And what is the rationale of being applied when these courts almost allow victims to continue to be assaulted, abused, harassed, while waiting for their special day to apply? The victim that was murdered, Ms. A. Korea, was murdered only 4 days after battling to get assistance of the court for the interim protection order. And this was highlighted in the PP's report. This surely highlights that once a week could never be enough if we're actually serious about the gender-based violence. Information received by the people also indicated that the applicant some applicants in the interim protection order must be served to the respondents by themselves. I mean, how can this be acceptable? I'm not sure that I need to highlight that this is ridiculous for obvious reasons. I mean, the victim must face the perpetrator and possibly can face assault or even worse again. Another question that arose while reading the report is, why didn't the Department of Social Development not create enough shelters for victims of GBV in the first place? I mean, it's not a new phenomenon. It's been ongoing, and the awareness for this specific plight began in 1991 with the first Women's Global Leadership Institute. In the report, it stated that there were 47 districts of GBV shelters. And I would like to know, what is the total bed space in these shelters? I mean, we could have 47 districts with shelters, but not near enough beds. So what is the bed space? And even if we don't have the bed space, even just the ballpark. In the Garankuwa Magistrate Court, I mean, the state of non-existent filings, has it actually been remedied? How is it that this court could find itself in such circumstances in the first place? Could these documents not have just simply been filed or, neatly stacked? And then who was responsible for this? Was it the court manager? And what actions was taken against them? We've received countless reports of many entities over the last few days and weeks Mention of dockets going missing just yesterday in the TRC matters. We spoke boldly about integrating the integrity and the protection of the Zondo evidence. Yet here in Garankuwa, the maintenance, the domestic violence and the harassment files are just generally accepted that it's thrown on the floor. Is that the respect that we're showing the public of South Africa? And then comes to the next question: do you beg that to differ that the public has no faith in the justice system? It's not a shock that then women, in particular, rather not open cases in the first place. Their cases are just simply going to be thrown on the floor of some cell next to a bucket and a mop. There was one thing that I did notice, we spoke about the renovations and photocopiers, telephones, and etc. I mean, these don't add specifically to GBV violence case per se, but rather to court process holistically. And I think it contributes to the total backlog of cases just in general. And lastly, I do want to commend the implementation of the GBV desks that were implemented at the police station. I think there's the 1,159 police stations. But yes, definitely, we spoke about it now previously by previous colleagues, but victim-friendly rooms must become a norm and standard. Imagine, just for a second, that it's your mother or child needing to report a rape in front of others, and in particular men, at some busy police station. I mean, the thought is absolutely just horrific. Thank you, Chair.
Thank you, Honorable Matafa.
Thank you very much, Chair. Good morning to you, members, the PP and the team and guests. Chair, let me join members who have thanked the sterling work by the Office of the Public Protector for such a report, and also join members who have suggested the holding of a joint meeting with those portfolio committees whose departments have been identified in the report. I think that will assist in us going forward in terms of eradicating these deficiencies. I just have a few questions, Chair, that I would want to pose to the Public Protector and the team. And I'm going to restrict myself only to the work going forward and what the report has identified, and would not definitely go into the inner workings of the department, because I think the joint meeting will allow us that opportunity to dig deeper into the nuts and bolts of dispensing justice for these particular victims. Chair, the first question that I have is whether the investigation might have exposed any common patterns or root causes to contribute to these deficiencies. My view, Chair, is that whilst we work towards eradicating the identified deficiencies, we should also be preoccupied with dealing with the source in order to prevent recurrence of such administrative deficiencies. Because it's well and good to implement the remedial actions from the PP, but if we don't deal with the source of these administrative deficiencies, we might have a problem. And if such root causes, Chair, have been identified, what would the PP recommend to the department to address and prevent these future administrative deficiencies in the unit identified? I'm asking this question, Chair, because in our oversight tour, we had identified Mamelodi as a court that we might want to go and visit. Now, the report indicates that the report, or the court rather, stands unoccupied or incomplete for over 10 years. What is the root cause of such a delay? Could there have been a person or persons identified to have been negligent or reneged on their duties that could have been held accountable or not? Maybe let me pose it as a question. Has the investigation identified any persons responsible for such deficiencies as it relates to the Mamelodi Court build project? And if so, were there recommendations made by the Office of the PP in order how to deal with these particular challenges? Chair, my third point is on the timeframes. I'm happy that the presentation speaks to the proactive nature of the department in trying to address these particular issues. My question is on the ones that are specified and are time-bound from the Office of the PP, how far are we into those timeframes? And what is the progress that the department would have been made? I'm speaking about recommendations like the need for collaboration, the need of presentation of code designs. I think in that submission, there were timeframes like 180 days, 90 days. So on the key remedial actions, if the PP can take us into their confidence to say how far is the department responding. Chair, I think the next question, my fourth point, it's almost the same as what Honorable Klopper raised in terms of the support that the victims are receiving while the department is responding to the recommendations emanating from the investigation. Has the PP identified measures that can be implemented to ensure that whilst we deal with this remedial action, at least the quality of service delivery to this victim improves in the interim? And if not, we'll then just park it as a question to pose to the department in our next engagement. Related to that, Chair, if the PP can just indicate if whether through the investigation, there were cases of victims being overlooked or poorly serviced that were identified or uncovered during the course of the investigation. And if so, how did the public protector deal with these particular cases? And what would they recommend for the committee to be seized with in trying to resolve these particular issues of poor service delivered to the victims affected by the scourge of gender-based violence? The last point, Chair, is on follow-up mechanisms. It's well and good to say, do the following by this time. Post the implementation or post-reporting by the department, does the PP envisage active involvement, or would they recommend a particular follow-up mechanism for the committee to recommend to ensure that whatever plans that are communicated to the Office of the PP are translated into action, into outcomes, and into the desired impact on those particular victims that we so desire to service? So that is just my reflection, Chair, and I thank you for the opportunity to participate in the discussion. Thank you, Chair.
Thank you very much, Honorable Nomvalo.
Thank you very much, Chair. And once again, greetings to all members present here and the public protector and her team. My first point, Chair, is that the SAPS is the most important, according to my position, is the most important institution on these issues of gender-based violence, because they are the first contact with the victims. So they are better placed to determine the success of prosecution and the adjudication of these matters by ensuring that they treat all the complaints meticulously and without overlooking any important aspect. So maybe it was going to be important, Chair, to also make a remedial action of enhancing the syllabus in the SAPS colleges. That will also, take into account the scope of GBV, on how the GBV cases must be, treated at the first point when they are lodged as complaints. Because I believe, Chair, that there's a lot of damage that occurs at the SAPS, the manner in which the cases are treated and the reaction, of the police to the victims. That is why we also have many unreported cases. But on the other hand, Chair, I think the unreported cases are also created by the existing socio-economic challenges, because especially on relationships, on GBV cases arising from marital relationships, because men with a financial upper hand will always find comfort in abusing women, and knowing that even if they lodge complaints against them, but at a later stage, because of their financial positions, they are going to withdraw those cases. Now I'm saying, and it so happens that they withdraw them. It's either they lodge such cases and withdraw them at a later stage, or they don't complain at all because they know that financially they rely on these men. I've seen a paragraph in the report of the public protector that talks about the unreported cases. So I just wanted to ask if they've gone to an extent of making an analysis of unreported cases and the root cause for such. Why are cases not reported? And I believe that many answers to that aspect were going to be, acquired through interacting with the public to get their sentiments. And the second question, Chair, that I would like to ask is because the public protector here is talking with the lawmakers. So she's at liberty to lobby us if there is a reason. Now, according to their observation with regards now to the legislative framework that relates to regulating issues of GBV, are there any legislative deficiencies which lead to administrative deficiencies? And if so, I know that it might be an ambush to say specifically they must list them now, so that as the portfolio committee will have a look and see how we can turn around so that we can ensure that we have an effective legislation that deals swiftly with the pandemic of GBV. And then the last point here that I want to make is that another problem that we have is that in some rural areas that are in the periphery, especially those rural areas which are far from the service delivery centers, there's a number of villages which still adhere to conservative traditional orthodox. Wherein you have people who still report the GBV cases to the traditional houses or to traditional leaders who actually have no insight or experience of how to deal with these cases, but they do make judgments. And to a certain extent, their judgments are final because of the confidence that the people have in them. They just adhere and respect their judgments, and the matters do not go further to designated and the formal institutions like the courts and the SAPS. Now, I want to check if during their investigation, I want to check if they went to that extent, especially in the deep rural areas, of checking if there are people really who still believe in the traditional houses, the result of which they still lodge their cases therein, and what is the impact, that modus operandi has in this GBV issue. Yeah, for now, Chair, I want to pause there. Thank you very much.
Thank you, Honorable Motaung.
Thanks, Chair. I'm covered.
Thank you, Honorable Mkwebane.
Thank you, Chairperson. Good morning, everyone. Thank you, Chairperson, and thank you, Public Protector and your team, honorable members. The comments I will be making about this report is that, firstly, the investigation started in 2020, and now it was issued possibly 3 years down the line. And that says a lot about us as parliamentarians, in the sense that, you know, such a report which should be used for future changing and supporting constitutional democracy and assisting Parliament to do proper oversight, is issued at this late time, because every year we have challenges of GBV, and but we've got a constitutional, in fact, the Constitution, the 3 spheres of government to do that. I will just want to say there's an opinion piece which was written by Dr. Gumani, one of our researchers, which was showing that executive and everyone is crying about budget cuts. And the budget cuts most of the time is as a result of you know, everyone blaming possibly National Treasury that you know, we need budgets and there's no money. So that is a very brilliant analysis, because the final arbiter or final decision maker as far as the issue of budgets is Parliament. I mean, Parliament, the budgets are presented, there's those cuts. Parliament has the final say of saying we don't approve these budget cuts. We return it back to you. National Treasury make sure that the Public Protector is properly funded, Department of Justice is properly funded, Department of Police, you can't cut so much budget, Department of Social Development. So unfortunately, we rush and approve such budgets and fail to see that the Treasury doesn't have special powers beyond politicians who have the right to decide, because the money bills is very clear. The Money Bills Amendment Procedure and Related Matters Act, it gives Parliament the final decision, and we can reject the budget, and we can even indicate what is a priority. I mean, one honorable member is saying GBV is like the second pandemic or the main pandemic, but it's easy for us to talk, and are we implementing that, and always blaming the issue of budgets and all those, because we will continue to have this continuing to fester. And another issue which I would like to add, Chairperson, which I think I raised during our induction process, but as well, I hope during the strategic planning session of Parliament, it will be taken seriously. Public Protector and other Chapter 9 institutions are constitutional institutions which are there to support and strengthen constitutional democracy. These institutions are there to make sure that as parliamentarians, because our responsibility in terms of Section 55 of the Constitution is to do oversight. And such tools and such reports help us to do our oversight. And now the problem is we end up burdening them. Now, currently, someone will be asking, how are you going to make sure that those remedies are implemented? It's no longer their responsibility. It's not their constitutional responsibility. Their constitutional responsibility ends with investigation, issuing remedies. That's purely what the Public Protector should be doing. Therefore, this report now, Chairperson, we agreed that you indicated that that notice without motion on a statutory rape of school children, which it will be going to the team of, in fact, the meeting in the programming committee with other portfolio committees, which Honorable Dana mentioned, that this needs us to be collaborative. This needs us to use this report And when we meet dealing with that issue of statutory rape, because it falls within that, and see how then do we indicate that DST, this is your responsibility. Make sure that this tool, this available report can help you to deal with problems in your area. And I like it that we also need to call upon the Department of Public Works and sit with that committee and hold them to account, because I think, Chairperson, such reports, and not only these ones, there are more reports which were issued, the systemic investigation, because Chairperson, if we do that, and we make sure that Public Protector and other Chapter 9 institutions are properly funded, they focus on investigations and they don't delay in issuing such reports. And we then take away the burden from them on making sure that these reports are implemented. And I am glad that the members, which the institution is now fortunate that there's this reception, that the report, the way it is, we as members of parliament, we should be enforcing it. The office shouldn't be enforcing it. And I think going forward in the strat plan of parliament, we should have a situation where, Chairperson, we treat the reports of the Public Protector there like the Auditor General's report, because it's compulsory for each department that in their annual report, you indicate what are your audit findings and all those. We need to reach a stage where when you present your annual report as justice, as SAPS, what are the findings of the Public Protector saying? Have you implemented them? What are the findings of the human rights? So we are here to do that, Chairperson, as members of parliament. Thank you so much.
Thank you so much, Honorable Mkhwebane. Honorable Nomvalo, did you leave out something? Or it's an old hand? Honorable Nomvalo?
Chair, no, I didn't realize that my hand is still up. It's an old hand. Apologies.
Okay, no, that's fine. That's fine. PP, reactions to comments and questions by members. I'm sure you would have noticed that in unison, the committee PPSA for the sterling work you have done. You'd know that not every time the committee commends institutions, and when it does, you must know that you really have done well. PP.
Thank you very much, Honorable Chair, and thank you to the honorable members. Indeed, we are trying our best with the challenges that we find ourselves in, but we've decided as an institution that we need to rise above those and actually not be complainants, because we need to instill confidence into the system. I will then hand over to the team, starting with Ms. Pillay, to give responses, and then Chair, I'll just round off on whichever they would have left outstanding. Thank you. It will be Ms. Pillay, Ms. Mokhaladi, Advocate Kabinde, Advocate van der Merwe, and then Ms. Sibanyoni, and then I will round off at the end. Thank you so much.
They can proceed in that order.
Good morning to the Honorable Chair and the Honorable members. I'm going to start with addressing Honorable Klopper's questions and comments. Thank you for the positive feedback regarding the report. You made a comment about how the courts have, or some courts have set aside one day to deal with protection orders. And yes, we completely agree that it is wholly insufficient. It's not a finding in all courts, but in certain periodical courts that sit, where magistrates come on a periodical basis to the courts. You will notice from the GBV trends that's happening in our country, it is insufficient, and that specifically needs to change. And the Department of Justice has given us an indication that that is something that they're going to actively look into. When you look at coming to the issue of service of protection orders, now we are at a stage where we have victims that are, suffering secondary victimization and going through all of this trauma. And now at the time of serving the protection orders, it's incumbent on them to accompany the SAPS to go and now serve this protection order. It is really, for me, an unrealistic expectation. However, it is still happening that, they have to accompany SAPS. And this is actually causing severe trauma, where some of the victims have indicated to us at the point of serving these interim protection orders, it's sort of a deterrent when they have to go back to the perpetrator, when they have to go with the SAPS, despite the SAPS being, what we term as some kind of protective intervention. It still has a severe impact on them, and that is something that we're seriously looking into. When we look at the issue of DSD shelters, yes, there are insufficient shelters. DSD has indicated to us that they are going to give us a plan for how they're going to make provision for more shelters. Look, we must commend them because they have made great inroads in having more shelters. And we have visited the Marley Martin shelter, like we've said. It is a fantastic, center. It is operating, it is functioning, it's got excellent resources in there. They even have counselors, they've got security as well, which is state-of-the-art security. We haven't had the opportunity to visit many more shelters, but the ones that we visited were operational, I must say. So we look forward to getting their plan and seeing what is their plan for our country, and to see in light of the fact that, this is a scourge of gender-based violence. When you ask the question about, it's interesting to note, and it's a very interesting question because there may be a shelter, yes, but how many people can the shelter accommodate is also the other question. So when we went to the Marley Martin Center, we noted that there were double beds and there were particular rooms where there were bunk beds that made provision for children to stay with the mothers as well, or with the victims. But it is something perhaps that we may need to look at in the future, or request that information from DSD, because we haven't during this investigation been able to determine what actually is the total bed space. Then there was another question and comment about the GBVCC and it being under-resourced. Yes, when we did visit the GBVCC, and you look at what the GBVCC systems are set up for, it's actually such a fantastic system, because even if a call is dropped, the GBVCC personnel can then pick up that call and call the person back. And what I liked particularly about the system was that it's the accessibility for victims, it's the availability of an immediate response service to victims of violent crime. So if you call into the center, you can actually hold on, or they can call you back if you don't have airtime. If you need to get an SAPS, and we actually tested the system without them knowing. One of our colleagues that was there called in the center, and she was immediately connected to an SAPS police station in the area where she said she was. And then they said, okay, we are dispatching a police vehicle now. So the system has very, progressive capabilities to assist victims. But unfortunately, what we need to do is we need to capacitate the system so that we can assist more victims of domestic violence and gender-based violence. The system also assists with and promotes effective referral among stakeholders. Say, for example, the victim needs medical attention. Then what would happen is that an ambulance will be dispatched to the house to assist the victim. Also, if you look at how the system is functioning, what we then did with DSD is we asked them to conduct what we call an impact study to evaluate how effective the system is. DSD in their responses to us have indicated that regarding the remedial action, because you asked how long, they said that they will respond to us and submit the information that we've requested by December. So we are positive and that we will receive those responses from them. Thank you.
Thank you. Let's proceed to the responses.
Thank you, Chairperson and honorable members. Honorable Breitenbach asked the question whether we observed during our inspection in local and visited other courts that had victim-friendly rooms. Out of the 38 courts that we had identified, the only one that had the victim-friendly rooms was a Point Family Court. At the time, the facilities were working, they were in excellent condition, but what we will do, because we intend to follow up once we have received the plans from the department, we will consider the other courts and we'll also look in depth into whether all those facilities they are working. But from what we observed from the Point Family Court, they are state-of-the-art facilities. They were utilizing them. For instance, there would be those projectors in the various family rooms and the TVs, and they were operational. The other question from Honorable Dana, it was around the address for the online portal. It is on the homepage of the Department of Justice. There is a link for online services where you can click on that. It requires you to register. What we have observed is that at the moment it's only in English. If you take people in the rural areas, there are still those concerns about accessibility, whether it is accessible enough. Also, the process of registering, it requires you to have an email address so that it can be confirmed. But the department has made undertakings that they are looking into all those issues that we have raised, and they are currently looking at it to try and make it more user-friendly. With regard to whether it is advertised, we will follow up as we do the follow-up inspections to determine whether it is available, whether it is advertised at the various courts. The one court that we visited towards conclusion, there was a poster that was placed there pointing towards the online portal. The other question from Honorable Nomvalo was around the syllabus for SAPS. SAPS has provided us with the detailed training programs that they are currently providing. But what we have noted was that there needs to be improvement in the various areas, and they have also undertaken that they are going to improve their training. We will be following up the remedial action for SAPS. The first follow-up date is the 4th of December. So we will be following up with SAPS on the 4th of December. We'll also look at the curriculum, because in terms of the information, they provided us with the curriculum for the current. We will follow up after they have reviewed their training programs. There was also a question that was asked to the public protector around what is it that we would request the members of the committee to assist us with. What we have highlighted is that there is the provisions of Section 18B and 19A in the amendments to the Domestic Violence Act. It is a recent amendment that requires the Director Generals of the Department of Health, Social Development, Basic Education, as well as Communications and Digital Technologies to develop directives that needs to be tabled to Parliament. At the time that we concluded the investigation, only the Department of Justice and SAPS had started the process. Other departments were still in the process, and we did not focus much on that because the timelines had not yet kicked in for them to make submissions. It might be one area that the portfolio committee might need to follow up with the various other committees to make sure that there is compliance. Justice is coordinating compliance with this provision of the Section 18B of the amendment. So it might be one area that the committee can zoom in and make sure that the directives are indeed. The aim of those directives is to make sure that there is awareness in the schools. If you look at the areas that are covered, is to make sure that there is awareness and there is compliance with the DVA, especially take into consideration the Department of Basic Education is one of the areas that is included. But part of the challenges that might be picked up was that some of these departments, it is the first time that they are implementing the domestic violence legislation. So there might be challenges, there might be the need for intervention. The responsibility lies with the responsible cabinet ministers. So the committee can follow up on that area. There was also a question around the root causes. And the root causes, particularly whether we have identified certain trends. What we have picked up, particularly with regard to the resources and capacity challenges, I think it is areas where, from the responses that we have received, they have highlighted financial constraints. And also what we are picking up is that there is that disjuncture between the Department of Public Works and the various, especially from the point of both the subs. Actually, it cuts across the three departments because the responsibility for infrastructure lies with the Department of Public Works, but there are some areas for challenges. What we have picked up, for instance, with the court in Mamelodi, the public protector met with the minister. The minister also highlighted that the court in Mamelodi was one of those courts that the department has flagged for follow-up. But what we are going to do is that we will follow up on some of those cases, particularly where there were projects that were identified. There were issues around procurement in the Mamelodi court. That is why it was not completed. And also with Harangu, where we decided that we will follow up separately on those investigations. And we'll follow up with the Department of Public Works, because those are the projects that were already handed over to the Department of Public Works. Thank you, Chair and honorable members.
Thank you.
Thank you very much, Honorable Chair. And on the issue of that was on the issue that was firstly, I would also like to welcome firstly, I would also like to appreciate the positive feedback from the honorable members, pardon me for the sound today, and the appreciation of the work that has been done in this very, very sensitive area. And one would want to see things turn around in really the country, because we are considered as one of those countries that, when it comes to gender-based violence, it's a high prevalence, in addition to the various crimes that are experienced. And there is going to be a focus, Honorable Swart, on the intervention measures that are put in place by the various departments, particularly in the rural areas, as we look into the various service delivery issues and expanding from what we had started in the Eastern Cape, but with particular focus in this particular area of how the Department of Justice, the police are actually responding to victims of gender-based violence, because all these intervention and resources and online platforms that are available are more accessible to people in the urban areas, and even the response time is more felt in the urban areas. So as we progress and looking into the implementation of the remedial action, we are focusing on this area, on how the South African Police Service, the Department of Justice, as well as the social development is actually advancing this area of accessibility of the various services in the rural areas. Honorable Breitenbach, in terms of the time frame and monitoring of the implementation of the remedial action, it's another area that we have included, also even right down to our performance agreement, so that we follow up on the implementation of the remedial action. And we do keep our own monthly reports and follow-ups and engagements with the various stakeholders. So this one as well, we are monitoring in line with the time frame that is set out in the remedial action, so that we ensure that there is impact, there is implementation of this remedial action as undertaken by the various departments. The Honorable Tsotetsi, there is a framework of what a court should actually look like, what resources and facilities should actually be there at various courts. And this is what we have held both the Department of Public Works and Infrastructure as well as Justice accountable to, that we can't, of the 38 courts that were visited, and noting that there are many more that we were not able to reach within the time frame of our investigation, that still may not be facilitated, that will have the facilities up to the standard that is required, but the standard is there. And that is what we are saying to both Justice as well as Home Affairs, as they then construct and conduct any renovations at these various courts, that they must uphold this standard, the basic standard that have been agreed upon in terms of what is adequate for a court to optimally function, but also to address and deal with the victims of gender-based violence in an environment that provides them with privacy, that provides them with dignity, and also sensitivity. And in addition to some of the underlying issues, the administrative deficiencies, we find that even where there are legislative measures or provisions that are in place, however, in terms of the actual implementation thereof, or the day-to-day activities. For example, we've shown now the honorable members how some of these courts look like. It therefore delays when they have to now retrieve or locate files for a matter that needs to be placed on the roll, leading to the users of the court having to wait a long period before their matters can actually be brought before court. In some instances, this leads to people getting disillusioned and even leaving the court. When we opened the Benoni Magistrates Court, our satellite office there, those were some of the issues where they were highlighted even by the court officials, that some of the victims, they then get disillusioned and they actually then leave the court out of frustration and maybe not understanding the processes because they are also not sufficiently explained. So we are also playing that role at the various satellite courts, offices where we have presence, including your Northern Cape and Western Cape, where we have various offices to also assist, but also to collaborate with the court officials so that these gaps can be closed from their side, instead of the public protector serving as an oversight body on a daily basis also on this issue. So the issue of record management, as highlighted, it really needs to be attended to urgently and resolved so that the court processes go smoother. The other issue that we had identified, particularly when it relates to the SAPS, was who is supposed to serve the protection orders. Because some of them were saying, but then the courts must also be able to serve. So again, emphasizing the issue that since the SAPS is available throughout the clock, they are the first also responders. That is why there is quite a heavy reliance on them assisting the victims, while we note the issues of a shortage of vehicles for them to respond on every other criminal matter that is reported, but the prioritization of reports or that relates to gender-based violence needs to be held in their own planning as well, because they raise that as a particular issue, that they can't dedicate vehicles to respond to GBV reports, and which also sort of touch a little bit on the lack of sensitivity in how they have responded, even as we progressed with our investigation, that there needs to be measures in place right up to their training, as the colleagues have touched on. Ms. Mokhaladi has indicated on a special investigation that we want to conduct on the construction of the Mamelodi court, because we want to delve into the procurement issues and whether there are procurement irregularities besides the issue of the court itself, not being completed after so many years. The issue of traditional courts, it's another area that we'll really have to delve with, which we did not focus extensively on in this particular investigation, and how then the victims of gender-based violence may be affected by some of the decisions that are taken there, which indeed are usually binding and conclusive, and sometimes even the arrangements that are entered into by families to the detriment of the victims of gender-based violence. Thank you very much. Thank you very much, Honorable Chairperson and honorable members. I hand over to the Public Protector.
Thank you. Okay.
Sorry, it's me first, Chair. Good morning to the Chair and to the honorable members and the team here. The responses I'm responding to are some of the issues that the members have raised incidental to the report, because the Public Protector has also been very active, especially during Women's Month and other occasions, to contribute and participate in the national dialogue on GBV and women issues. And some of the issues that the members have raised have actually came up during those engagements. I just wanted to alert the members that this is a systemic investigation, but we are also aware of the national strategy on the prevention of GBV, which is a comprehensive strategy that currently involves over 400 individual members, 82 organizations, all the departments. So in the first place, to conduct any systemic investigation into areas, and they've have over 146 indicators with 6 pillars. We have to focus on the areas that we can provide value, and the scope was informed by the complaints to the Public Protector. But it's one of the most research contributed, funded areas of our society at the moment. So the members of Parliament can also look at the CGE report on the implementation of the strategy, as well as the implementation report that would contribute and highlight the fact that to get information on and evidence on these matters, it is quite a labor-intensive process. On the issue of funding, I support Honorable Nkwebane that this is a critical aspect. From what we know from the national strategies that they've KPMG, I think in 2015, estimated that the cost of GBV is close to, and that's 10 years ago, between 25 and 42 billion rand annually. It must be much more. And the funds that were committed to the national strategy were 21 billion rand, and 50% of that has already been spent, but only 10 of the 146 indicators have been costed. So there's a huge problem in aligning to say that we need additional funding. The items must be costed and it must be prioritized. Similarly, there will be funds available from the committed funds, from the department's baseline, as well as their priorities in terms of the strategy to execute some of the remedial action of the Public Protector. Also wanted to touch on the issue of underreporting, because it is of grave concern. Incidentally, while the number of reports are contributing factors, one of the studies revealed that the actual identification of perpetrators, the loss of documents, and then the manner in which crime statistics are being collated are contributing factors to the underreporting of crime statistics. In one of the national dialogue forums, the public protector actually supported the fact that domestic violence cases, including femicide and GBV, needed to be desegregated from assault, murder, and other interpersonal crimes statistics such as violence on women, children, and men in order to provide more accurate statistics. Then on the issue of the root cause, the scope of this investigation was focusing in, as a systemic investigation, it did look into the causes of the systemic failures. But a root cause investigation, given the amount of investment that there is in terms of the national strategy and 146 indicators, would be a colossal exercise, but still focusing from the committee side on the root causes that implicated these departments. We feel that there has been at least the basis on which the committee can work from, and that's it from my side. Thank you, PP.
Thank you, Ms. Sibenya.
Good morning, Honorable Chairperson and the honorable members. Just to echo my team sentiments, we really appreciate the positive feedback, and we always strive to produce impactful reports. I think most of the issues have been covered, and I just want to appreciate the realization by the portfolio committee that there's a need for it to work collaboratively with other portfolio committees to minimize the risk as well of departments playing, the blame game. Because if you don't get everybody together, then you call one department and then that department blames the other department. So if you get everybody together to come and have their say, at least you get a better view of who was supposed to do what, and then that gives you an opportunity as well. But the other thing I thought probably the portfolio committee, the honorable members can ask the department to share with them the plans that they've shared with the audit, with the public protector, because then the committee can use those plans to as checklists as things happen, and then we can go to the checklist and say, but you said to the public protector, you're going to do this by this date. Have you done it? And where's the evidence to do that? So that will also help the committee. But otherwise, PP, all the other issues I believe have been covered by my team. And I just want to take this opportunity to also thank the committee for the opportunity presented. Thank you, ma'am.
Thank you so much, Chair. Just a round off on my side. I just want to touch on the issue raised by Honorable Swart regarding the Appropriations Committee's role. We actually had a meeting with the chairperson of the Appropriations Committee about 2 weeks ago, but on another matter, on an investigation which we had concluded regarding the Maibuya schools in Gauteng. We touched on this issue and how the Appropriations Committee can actually assist, particularly when departments raise the issue of the budget as a defense to the implementation of the remedial actions taken by the public protector. So we've agreed that we will have a follow-up meeting with the committee, which our parliamentary liaison unit is busy arranging in this respect, because it is really necessary that the committee also looks into these particular factors. Honorable Breitenbach, on the issue of infrastructure maintenance, we have flagged that in the report, and we didn't visit the particular court which you are referring to, but we will do so as part of our monitoring mechanism in respect of this report. But the department, as part of its implementation plan, part of the commitment is to ensure the maintenance of the infrastructure, the equipment that is required. But I must really flag our ICT system as a country, it is a problem. We struggle from that. We got cut about 2 times during our presentation to this portfolio committee alone. And that is really impacting also in the courts, because it is the CETA to which everyone subscribes to, which really is a challenge in this regard. Honorable Dana, on the issues of the timelines, Ms. Mokhaladi has already responded to those. Really, what we are doing now as an institution is also to align in terms of Rule 43, subsection 3 of our rules as the public protector regarding the enforcement of our remedial action, but also the contempt part. And what we are actually going to start exploring is, because the rules do not specify what type of contempt. Now, as much as we have put the proposal to the amendment of our act, particularly to specify on the criminal proceedings, but we are going to explore in terms of Rule 43, subsection 3A, the criminal contempt proceedings in respect of the non-implementation of the remedial actions, just to ensure that we become impactful as the public protector. The reports alone do not make us to be impactful. We might issue the reports, but if the prejudice in the life is not actually changed through the implementation, then those who complain to us and the members of the public in general really do not see the impact of the work that we do. Honorable Tsadetsi, we really support that portfolio committees need to also align. So what we did starting from the previous term, the public protector has been providing all reports finalized and issued to the speaker to ensure that these are distributed to the portfolio committees, so that the portfolio committees can have those into consideration when performing oversight. We have seen an increase in the portfolio committees actually calling us to explain these reports so that they are able to hold the necessary state institutions accountable. But further, we have realized that we have fallen short as an institution to implement, firstly, the notice to our respondents for the tabling of our reports. So already now, we've highlighted those reports which we would actually want to table, not just to the National Assembly, but to the NCOP, but also to the provincial legislatures, which we think have got a broader or a more root cause impact in respect of the findings and the remedial actions that we would have taken. Yes, we agree. There has been progress made, but also there has been a regress in terms of attending to matters of gender-based violence, because the conviction itself does not serve as a deterrence. It is a multifaceted approach that is required in this respect. And there are some developmental decisions that need to be taken. And we've started to engage with the DSD, with justice, as we were attending to this systemic investigation. First and foremost, as we see the growth in the reporting, but also those unreported cases where some of these women end up destitute, is that, must it really be the woman who leaves the home? Isn't that further victimization? You know, is the system not creating a further victimization, because the woman and the children either end up in the shelters with other family members or end up destitute, and the actual perpetrator is in comfort in the home? So those are the things that the system is going to have to start looking at differently, because there will never be enough shelters, especially whilst we are seeing the scourge increasing. But also what needs to be looked at from the parliamentary view is the monitoring on the implementation of legislation passed by Parliament. And I think really that is where it starts, and that's where probably when these institutions and departments report to the portfolio committee, that needs to be the start point on how far it is, what are the budgetary issues in ensuring that there is full implementation of the legislation, even before those legislations are actually amended. You know, as much as we welcome the amendments, but some of them amendments are not budgeted for. And 5 years, 10 years down the line, we do not see the impact, but also because of the budgetary challenges or the manner in which the prioritization of the budget is being done by the institutions and the departments. Honorable Clapper, I think I've addressed the issue of the shelters in that respect. But I think broadly, it is the issue of prioritization. And I think the Department of Justice has really been battling with prioritization, especially when it comes to its court services, because we've really seen a regress in that respect. Honorable Matafa, through the investigations in this, you know, yes, the service delivery to victims of gender-based violence is poor. It is poor. So, but our report in respect of the remedial action addresses how that can be addressed by the department, or rather should be addressed by the department, as the remedial actions are actually binding. And yes, the remedial actions are actually futuristic, dealing with the deficiencies, dealing with the root causes in this respect. Hence, we decided to go the route of a systemic investigation, which its purpose and objective is actually to highlight the root causes, to ensure that it is not just one complaint that is being attended to, but broadly. Hence, in there, we are asking the department to do an audit. So it is not only focused on the 38 courts that we looked into, that was just a sample, but the remedial action applies broadly, not just to justice, but to DSD as well as to the police. So their implementation plans, as we would start monitoring from the 4th of December, deals with all the areas which they are responsible in. So it definitely deals with the systemic deficiencies. The COO advises me that they've already started to discuss the specific investigations into the malfeasance in procurement, particularly into Mamelodi, but will consult with law enforcement to see if there isn't investigations which are ongoing, because we are really avoiding to duplicate, considering the budgetary constraints which we all have. Honorable Nomvalo, you know, the traditional courts, we have not looked into this aspect holistically, even in the GBV case, but what we have started having a discussion on as an institution is that we, considering the patriarchal system generally in our country, and also that the traditional leadership of our country is vastly and largely male. So we have to see how the traditional courts act is actually being implemented, and how that is being received, its impact and effects on members of the society generally. So once we see a rollout of that, we will then start to do an own initiative where we will sample off around the areas and see how that it is how it's being received and how it is actually impacting members of society. Really, the root causes of unreported cases and withdrawals of cases, as you've correctly said, is the issue of the socioeconomic factors. You know, I mean, statistics are there, the unemployment rate, the poverty, which mostly affects women, and women are dependent on the perpetrators largely to take care of them, to take care of the children. So the systemic investigation into our maintenance system, it's part of the issues that is looking into, is the legislation responsive to those issues where the woman is not further victimized? Because we have actually identified maintenance as also a part of gender-based violence, but it is so vast that we had to do it on its own. Accessibility is a problem. The exposure that victims are subjected to within the court system is also a challenge. The confidence in the system, as we see the system struggling, it also deals with the issues of the confidence. The issue of the bail, which has been addressed by the amendments to the Criminal Procedure Act, that is a major factor which complainants actually raise with us. The stigma that is associated with gender-based violence and so forth, and the time within which these cases are finalized is also a particular challenge in this respect. Honorable Mkhwebane, I think with the background that you have with the public protector, you are very correct around the issues of the budget, but not just for the public protector, but also for other institutions. Advocate Shamila Batoy raises the issue of gender-centered budgeting very clearly, that, you know, as a country, we need to consider that when budgeting is being done. The public protector issued the investigation into the state of the healthcare system in the country, which deals with issues of GBV. Hence, we did not dwell on them in this systemic investigations because they are addressed in that report. But also the issue of how women are attended to, prenatal, postnatal care, the maternity wards, etc. That report has still not been implemented, and the Department of Health vastly is raising the issue of budget, which impacts on how the public protector is perceived in doing its work. You know, I really do not think that the Constitution had intended that the public protector would end its mandate with taking remedial action. Our rules take it further on Rule 43, subsection 3, where it speaks on enforcement and when it speaks on us taking up contempt proceedings. So the law places a direct responsibility on the public protector to ensure the implementation of its remedial actions, which I must say, Chairperson, it has improved. We were initially on 0.5%. In January 2023, we were at 2% on implementation. We are currently sitting at 29% of implementation. Now, there's a lot of work that comes to this to ensure that we become impactful as the public protector. Complainants come back to us when the report is issued and actually not implemented because there is no change. The privilege perpetuates, and therefore we cannot say we are impactful as an institution until that is actually being done. So that is part of the work that we are putting in place, but it does come at a cost. Notwithstanding the long outstanding backlog which the institution has had, but also that we are screening matters properly now. Firstly, to ensure that the matters that are before us are correctly before us as the public protector. We have found out that some of the matters that are before us are not correctly before us. Some of the matters that are before us, we do not have the capacity to investigate them, but there are other institutions which are investigating those matters, which also have jurisdiction over those matters, the issues of duplications. So that is why some of these matters take time. But honorable members, as we accept really and appreciate your response to this investigation, you would have noted in the report that the reports of the public protector have transformed. You know, how we draft these reports, how we interact with the respondents. It is also to have them to have confidence in our investigative methodology, in our investigative process. Yes, it is upon the public protector to ensure that how we run the investigation and so forth, but we need to build a relationship with our stakeholders so that when the report is issued, whether they think they don't believe in it. They probably think they've got certain prejudices on their side, finance and etc. But the report must be convincing enough that it is an implementable report, which really takes a process and which this particular report has undertaken. Our quality assurance processes are quite vast, and admittedly so, part of it is to ensure that we issue credible reports. And again, Advocate Mkhwebane, we really appreciate your stance in that the portfolio committees, Parliament at vast, have got a responsibility in ensuring oversight, and that really some of the matters that come before the public protector, it is matters that legislative oversight should have dealt with. But also, members, we are attending to those, for instance, looking at how the legislature is attending to petitions, because the neglect or the undue delay in the petitions ends up with putting a burden on the work of the public protector, because it's either members of the public would then report to all institutions and see which institution actually attends first to the particular matter. But with that said, I hope we've really attended to all the questions. If there's any that we would not have attended to, it is really maybe because of an oversight, but we did attempt to do so. But we really appreciate our portfolio committee, the honorable members on this portfolio committee taking the time to interact with these reports. I think it is sending a message out there that the work that we do as a public protector is being taken seriously, and that we've got the support of the portfolio committee, but also other portfolio committees are actually going to follow suit and see that indeed this Parliament is serious in respect of oversight. Thank you very much, Chairperson.
Thank you very much, PP. Members, I think that covers in the main the issues that were raised by members, which I think from my point of view has been covered satisfactorily. Now, I think it is important that we take this report as part of our guiding documents in oversighting GBV. I think our management will be able to highlight some of the issues that are raised by the report, so that we're able to shoot straight where problems have been raised in regard to GBV. I think we all would recall that Parliament has passed 3 GBV bills in the 6th Parliament, which serve as a strong instrument to ensure that the fight against GBV and femicide in South Africa has been is accelerated. You will all recall that in a number of addresses by President in Parliament, he has actually pointed out that GBV is and should be treated as a second pandemic. This dates back from the time when the country was engulfed by COVID-19. So I think we should take the GBV matter as serious as a second pandemic as declared by President. Thank you very much, PP. I think what we can follow up now, which will be in the 3rd term, will be the report on the investigation on maintenance. I think you have indicated that you are conducting an investigation regarding maintenance issues. I think Honorable Dana would have raised some of the problems with maintenance costs and stuff, which I think that report would serve as a proper response to those things, and there is a proper indicator on what are the real issues on the ground as it relates to maintenance, and therefore help the committee conduct its oversight work efficiently. part of what the report raises, which relates to court infrastructure, is something that the 6th Committee has highlighted as well to the National Assembly. Was as it conducted its own oversight program, we have taken note that there are some courts in the country that are still in a very dire situation that warrant an urgent resolve and would have hoped that the process that relates to court buildings and court infrastructure would have been accelerated when the president spoke about cutting the red tapes. Part of what we face as the justice family is a blame game that usually gets played between the department and public works, which is something that we have been firm on, saying it must quickly be resolved, because the department would blame some of the delays on infrastructure development in our courts to the Department of Public Works and stuff. So I think it's one of the things that we shall note, and we have already covered this aspect in our oversight program that we are to conduct at the end of this year. But I think there are some courts that we have noted as what Honorable Zotets would call an ideal court. I think in the last administration, we visited a sexual offences court in Khayelitsha, Cape Town, where we saw a state-of-the-art infrastructure, where if victims are children, they have a separate room, holding room, that has a screen in it that connects the victim to the courtroom, so that when a need to testify arises, that minor is not exposed to the courtroom, but rather connected to a screen to the court and the holding room. I think it's one of the infrastructure that we have noted as state of the art, and actually gives us an idea of what then would be an ideal court. It is correct, members, that we need to do a collaborative work with social development, DPW, SAPS, for a coordination of this work, because if we are to operate as these portfolio committees in silos, we'll miss other parts, because I think all these departments have a role to play in ensuring that the fight against GBV is strengthened. We therefore look at the proposal on having a joint portfolio committee meeting, where rather we shall receive reports from all the ministers relevant to ensure that in a collaborative way we accelerate this fight against GBV. Of course, I think it is important, PP, for your noting as well, that the issue of missing the turnaround times is actually noted, and as suggested in the meeting, we should be able to update the committee on meeting the turnaround times and stuff. You'll do that in writing. There won't be a need for us to have physical meetings here and then to receive the update on turnaround times. Members, I think let's given this report that actually points out critical issues relating to GBV, we need to go and relook our oversight program. But let's do that in the third term to ensure that it actually aligns with what the Public Protector South Africa would have reported today, and what the department would have reported in the past meetings relating to GBV and staff, court infrastructure, because I think this is a very important aspect that the committee should also play an aggressive oversight on. Members, I think for now, we have come to the end of our meeting. We thank you very much for the robust engagement to this report. And of course, commending the work that has been done by Public Protector South Africa and actually committing to play our own supportive role to ensure that all these remedial actions the PPSA has done are actually implemented by the relevant departments. PP and the team, we want to thank you again for coming and deliver this very concise report to the committee, which actually also helped the committee in directing its oversight program towards to where it is mostly needed. So we wish to thank you for coming to the committee and make this presentation. We take it with warm hands. We are going to do the best we can in ensuring that the committee actually helps ensure that what is contained in the report is actually realized. So PP, thank you very much, and your team. Members, thank you very much as well. You know, part of what PP have noted about our committee is that when reports are submitted to the committee, members take it as their responsibility to ensure that they read through so that we are able to guide what program should be designed in ensuring that the contents of that particular report are actually seen through. So members, also we need to thank you on that. Just an announcement that tomorrow I expected to table the report in the House as the committee, the report on draft notices on draft notices determining the salaries of magistrates, a draft notice determining the salaries of judges, draft notices determining the salaries of the Public Protector South Africa, draft notices determining the salaries of the South African Human Rights Commission. Maybe PP, because you are already here with your team, we'll just brief you that the committee has approved 3% increment for salaries in the Public Protector South Africa. Members, that all being said, thank you very much, and the meeting is adjourned.
Thank you, Chairperson.
Thank you, honorable members.
Thank you.
Recording stopped.